In principle, a civil partnership and a marriage provide a couple with the same rights. The Civil Partnership Act allowed people of the same gender to be able to engage in a legally recognised union from 2005. Prior to that, there was no option for people who were of the same sex to be able to engage in a form of legally recognised union, because marriage wasn't afforded to same-sex couples. So the government sought to resolve this by bringing the option to engage in a civil partnership. However, since 2014, people have been able to get married irrespective of whether they are of the same gender, and therefore people have the option to engage in a civil partnership or marriage irrespective of whether they are in a heterosexual or a homosexual relationship. The application process for the dissolution of a civil partnership and an application for a divorce is essentially identical, in that an application is made to the court, can be done online, and does not require the applicant to provide a reason why the relationship has irretrievably broken down. It is sufficient to say that the relationship has broken down and that either a divorce or a dissolution of civil partnership is sought. The court will then grant a conditional order once 20 weeks has elapsed from the date of the application, and then once a further 6 weeks and a day has passed since the date of the conditional order, then the applicant is entitled to make an application for the final order, which is the order that ends the marriage or the civil partnership and replaces the marriage certificate or the civil partnership certificate. People who are married or in a civil partnership enjoy the same rights in relation to both parental responsibility and financial provision. It means that both parties are able and entitled to make decisions in relation to their children. It also means that they can make the same claims in respect of financial provision in terms of both maintenance, property and pensions.